Good afternoon, everyone. Thank you very much for participating in this live webinar. My name is Olga Petrovic, and I head the maritime finance practice here at Linklaters, as well as co-heading the firm's transport sector. The webinar is being sponsored by Linklaters and by 36 Stone for LSLC, the London Shipping Law Centre. A warm welcome to you all. Along with 36 Stone, Linklaters is delighted to be hosting this event for the LSLC. Last November, it was a particular pleasure for me to attend the Centre's 25th anniversary celebrations as a guest of Mediator. With some other 300 guests, I was able to join the congratulating the Centre's founder chairman, Dr. Leggatt, on the Centre's very significant contribution over the past quarter century in acting as a focal point not only for lawyers, but also for market professionals from shipping, commerce, finance, and industry. Particularly noteworthy are the opportunities for young professionals, which the Centre has successfully opened up. From the very start, the Centre has had the support of the senior judiciary. The tradition continues today with the most recent Lord Chief Justice of England, Lord Thomas of Cumbead, graciously accepting the presidency of the Centre. At the Centre's 25th anniversary celebrations, Lord Thomas gave a wide-ranging speech, which included a brief discussion of the challenges of pleading good faith in English law. On that occasion, Lord Thomas cited an expert that he had encountered in his very early days at the bar, who advised that resort to the doctrine of good faith was always the sign of a pleader in great distress. It was Lord Thomas's comment that provided the impetus for the Centre's Education Subcommittee, under the chairmanship of Vasanti Selvaratnam of QC, to organize today's roundtable discussion. Please may I now introduce you to the chair and mediator of this webinar, Sir Bernard Eder, who practices as an arbitrator, is a serving international judge of the Singapore International Commercial Court, and was judge of the High Court of England in Wales from 2011 to 2015. Sir Bernard has been a staunch supporter of the LSLC and has chaired many of its events over the years. Sir Bernard is also appreciated by the members of the LSLC for his infectiously enthusiastic chairmanship and for his great sense of humor. Before I turn proceedings over to Sir Bernard, just to know that we're very keen to ensure that there are some questions put to the panel, and there is an email that is flashing before you on the rotating slides that hopefully everyone is seeing. So do please send your questions along and they will be collated and put to the panel. May I now pass the microphone to Sir Bernard so that he may extend his own welcome and introduce today's panelists.
Well, thank you, Olga, and welcome to this debate on good.
Until Sir Bernard has come back online, let me say that I'm delighted to be involved in this webinar with my co-panelists. There should be short bios for each of us appearing on your screens on the webinar flyer that you will all have received. And Bernard will be very well known, I'm sure, to all of you. He has a particular interest in the subject of good faith, albeit his views will not necessarily mirror those of everyone else on the panel. We have a series of questions which we hoped would be interesting for us to debate. And the first of these concerns what is the approach of English law to good faith. And I was going to start off by speaking very briefly on that before passing observations to my co-panelists. Unlike many other jurisdictions, English law does not recognise a general duty of good faith applicable to all contracts. Instead, it's developed very much a pragmatic and piecemeal solution to demonstrated problems of unfairness. And this was noted a considerable time ago by Lord Justice Bingham, as he then was, in the case of Interphoto Picture Library and Stiletto. Examples of these piecemeal solutions include the approach of English law to the exercise of contractual discretions. It's now well established that where a contract confers a discretion on one party and the exercise of that discretion has the potential adversely to affect the interest of another, then the discretion has to be exercised honestly and in good faith. and that's now known as the Braganza principle. However, given the pragmatism of English law, they've carved out an exception for the approach to termination clauses, and they are regarded as something quite different from contractual discussions, and thus they're not subject to any requirement that they be exercised in good faith. The most recent example of this is the 2020 case of Tacker and Rockrose. Similarly, in relation to option clauses, which are drafted in absolute terms, again, they are not subject to any requirements of good faith. That's illustrated by the Cathay Pacific and Lufthansa case in this year. We have developed principles of construction that are designed to prevent bad behaviour, namely the principle of construction that prevents a party from taking advantage of its own wrong. We also have implied terms about necessary cooperation and not preventing performance. We also have our law on misrepresentation and deceit, in addition to the law on estoppel, and we've developed principles in relation to fraud on a power. However, outside the special context of these pragmatic examples and contracts between fiduciaries and insurance contracts, and now relational contracts, about which others will speak later, English law generally refuses to recognise the existence of any overriding obligation to perform commercial contracts in good faith, and indeed has shown a marked hostility to the notion that there should be any such general principle, absent the existence of an express term requiring good faith dealings, which the English courts will generally seek to give effect to. Now, the failure of English law to recognise an overriding principle of good faith contractual performance has polarised members of the English judiciary. Now, as many of you may know, Lord Leggatt is a good faith supporter. He's written extensively on the subject, has also spoken to that effect, and his seminal decision in Yam Seng will be well known to many of you. Now, his elevation to the Supreme Court, I think, bodes for very interesting times on the highway of good faith. I'll pass over to my colleagues to see if there are other observations on the first question we wanted to debate.
Well, I think the first question we were going to debate is down to me, which is should we be willing to introduce into English law a general doctrine of good faith? I think Bernard may be joining us in a moment, but I'm going to kick off and answer answering that question. And I'm going to put my cards straight on the table and say that I am a skeptic about this matter, and I'm a skeptic for a couple of reasons. But before I say why, let me say at the outset that I really have no difficulty at all with the idea that people can, if they want to, import into their contracts an obligation to act in good faith. So that could be done on the basis of an express term. I have no problem with a term being implied into a contract on that basis if the usual tests for the implication of terms are satisfied. And if there is a term to that effect, the courts really need to do their best to give effect to that agreement. It could very well be extremely unclear what the parties are actually intend, but it's one of the jobs of the court to sort that sort of thing out. So no problem at all with the principle of having a requirement to act in good faith in contracts if the parties agreed that. But my skepticism really relates to the introduction of a general doctrine of good faith, which is one which is, if you like, imposed on the parties, perhaps unless they've contracted out of it, rather than one that they can be said to have agreed to. And there are two reasons for that. The first reason that I'm skeptical is that the concept of good faith is one which really has no clear meaning, and it has a different meaning in different contexts. So, for example, the duty of utmost good faith in insurance law has a very particular meaning. The duty of good faith in the context of the Consumer Rights Act looks at questions of whether there's been an inequality of bargaining power and whether an obligation has effectively been imposed on the customer. Good faith in the context of the exercise of a contractual discretion is about fairness, and if you're trying to make an assessment about an objective, whether you have made a genuine attempt to do that. So it has different meaning in different concepts. And so to have this duty imposed on contracting parties will inevitably introduce a significant degree of uncertainty into the law of contract, and be very difficult to predict what the conclusion would be with any certainty. Now, I completely accept that that is a soluble problem. If we had 25 years of litigation, we could build up a body of case law which would make it clear what good faith means in different contexts. So it's not a problem which is something which can't be solved. That takes me on to my second objection to this, or a second reason why I'm skeptical, which is an objection of principle, really. And that is that I think that the imposition of a duty to act in good faith has the potential to undermine the principle of freedom of contract, which is one of the most fundamental principles which runs right the way through the law of contract. And that obviously is about giving effect to the parties' intentions, what they have actually agreed, rather than what's being imposed on them. It's perfectly correct to say that there are other areas in the law of contract in which consequences are imposed on the parties, whether or not they've agreed to them. An example of that would be Untitled Terms Act. Another example would be the law of frustration, which is not based on an express or implied term. But these address particular issues, and they don't apply to contractual obligations generally. And my concern about the introduction of a general obligation to act in good faith is that, as it suggests, it's a general obligation which doesn't address particular issues, but which would apply generally to all contracts, which cuts across the principle that contracts are based on essentially agreement between the parties. So let me leave it there. I'm happy to pick up on any of those points later. Perhaps we could move on to the next speaker and see what other views have been expressed.
For myself, Simon, I find myself in agreement with you, but for different reasons. The problem...
Is that me? Oh, sorry, go on. Go.
Richard, yeah. As I was saying, Simon, I agree with you, but really for different reasons. To me, the essence of the problem is the different sectors of society have different needs. Consumers, small and medium enterprises, large corporations, players in the wholesale financial markets. Now, as we both know, the leading case last year on good faith was Bates against the Post Office, a 300-page decision, by the way, in which Mr. Justice Fraser set out a non-exclusive list of 9 points to determine whether a contract was what he characterized as a relational contract. In that instance, he found that the contractual arrangements comprised a relationship contract, and so therefore there was implied a duty of good faith and a full disclosure. In my view, 2 issues arise from Bates. First, I think that the facts are instructive. The Post Office accused hundreds of workers of fraud, ruining many of their lives. In fact, a faulty computer system was to blame, and it was reported in last Saturday's Financial Times weekend magazine that the Post Office on settling the case, paid out 57.75 million. Now, it may be that we are no longer a nation of shopkeepers, but certainly we are still a nation of small and medium-sized enterprises. And for example, according to recent figures produced by the government, small and medium enterprises account for 47% of all private turnover in the United Kingdom. And the number of employees they have on average is 10. Now, from the point of view of contract negotiation, there is often anything but a level playing field in small business to big business contracts, or in the modern argot, B2B contracts. I think we would agree that small and medium enterprises are in a weak bargaining position. And it is because of that I would suggest that we consider the Belgian law of 4th April 2019, which recognises that the existence of an imbalanced bargaining position is likely to lead to unfair practices. That law, by the way, doesn't apply to all B2B contracts, just certain of them. Now, there is already some precedent for relaxing the severity of English law. For example, an EU import is Section 62 of the Consumer Rights Act, but this only applies to business-to-consumer contracts. My co-panelists and learned, very good friend Philip, in his 2015 book, The Fall of the Priests and the Rise of the Lawyers, graphically and with beautiful imagery expresses the point. The consumer is made God by the statute makers and strolls around the park, humming a tune, clothed with invisible armour. My suggestion is that SMEs would welcome not just the invisible armour of relational contracts, which flow on from Mr. Justice Fraser's decision last year, but also that their protection needs to be further buttressed where there is significant imbalance in their rights and duties vis-à-vis the other contracting party.
Well, thank you, Richard. Bernard Eder here. I'm not sure anyone can hear me or see me, but I am back. And it just shows you the wonders of technology fail occasionally. But I have heard, I think most of, I didn't hear what Vasanti said, but I know her views. And I heard the end of Simon and what you said, Richard. And my welcome to everyone around the world, I'm afraid, faded at the crucial moment. But what I'd like to move on to is the next question was whether England is in line with other jurisdictions, and can English law learn from other jurisdictions about the desirability or non-desirability of a general doctrine of good faith? Philip, would you like to comment on that question?
Yeah, I'll certainly have a go. But first of all, I'd just like to thank Richard very much for giving my book a plug. It really does. Now, look, I'm a very sort of simple bloke, and I love colours. And there are an awful lot of jurisdictions in the world. And so I really got together 321. They're on this map if you're interested. I'm not going to go through every one, to be honest, because I haven't read all their law for one thing. But you know, they're basically in big groups. And there are 3 groups which have got 85, their ideologies really, they don't belong to the countries, but their ideologies prevail in about 85% of the world for various historical reasons I don't have to go into now. Now, what I'm going to do is to characterize by color the attitude of each of those groups to the good faith doctrine. So we'll start there, then we'll finish with that. Now, the most enthusiastic are the Napoleonic Group which is a very charismatic group invented by France, widespread, about 30% of the world. And that group is, on my count, red. They are the most enthusiastic about this doctrine of good faith. Now, on the other hand, just across the channel, there is another much smaller country, actually, territory called England, which actually, its system of law is inhabited in also about 30% of the world. So they, and if you include the Americas, it's about 40%, but I'm treating New York as separate on this discussion. Now, they are completely blue on this issue of good faith. You could say there's some sort of pinkish little dots here and there, but to be honest, I have yet to read one of the cases on good faith, which I think is absolutely outrageous. So I think that's their view. And what they're really saying is they want contracts to be predictable. I'm talking about business to business, by the way, and I'm not talking about dishonesty or anything of that sort. And their view is that people should have freedom of contract, and they say, okay, you're the parties, you make up your contract, and we'll enforce it unless it's really below the level. So they're blue. And then you have Germany, who also the founder. The basis of German law is a fantastic product, you know, it's like their cars. And they have about 20% of the world. Now, they sit in the middle. They always do sit in the middle on things like this, on the law. You know, moderate, and there's a lot to be said for that point of view. So I would describe them as sort of magenta or mauve, depends how much purple you want to put into it. Then we have to look at New York, which is a common law based on English law, but it's completely different. Now, my character to them, and I very much apologize to Americans, but I think that's been my experience, is that they are red today and blue tomorrow. You can't actually tell which way it's going to go. And that analysis seems to me justified by some insolvency indicators I did, which I'm showing you there. Of course, you can't see them, they should be, but the red is the Napoleonic Group. In the middle is the Roman Germanic, and the blue is the common law. So I think that's more or less. So where does that leave us? What it leads us to is that the international business community have a choice. So that's good. You know, there's competition. If they want a legal system to govern their contracts, which has a good faith doctrine, yeah, go for it. Go for French law or Belgium or Spanish or Italian or Luxembourg, and you will definitely get that. So I think if you're a debtor, then if you want the courts to look after you, that's what they're going to do. They're going to tend to work in your favor. But if you're a bondholder or a bank, I think you really need, or you know, you're trading derivatives where you want the amounts are so huge, you negotiate your contracts, you put in grace periods and all these things, then you should stick with English law. If you want a market, the power of a market behind you, then you can't beat New York law, frankly. But it's not because of the doctrine of good faith, because it's all a bit shaky. Anyway, that's really all I meant to say. And I think comparative lawyers need to fill out the subject. So as I come back to the point that, you know, we've got two legal systems which are international public utilities. One's English law, one's New York. Between them, they've got about 80% of the big market. So their legal systems don't belong to them, you know. We in England, we're just custodians for other people. It's not ours anymore. It's an ideology. And so we have to view it from that point of view. Thank you very much.
Well, thank you, Philip, for that. Before Vasanti comes in, I'm going to ask Vasanti another question, if I may, and that is, does it matter that English law is, as some might say, out of step? Does it matter at all? But before she does that, I do want to lob one question in. She either can or can't deal with it as she likes, but the others may want to come back to it. But I'm interested in what is meant by good faith. Faith is a matter that one might say is a matter of religion almost. But does faith in this context mean honesty? Does it mean fair dealing? Or does it mean something between that, between those two? If it means honesty, it might be said, well, English law has lots of principles to deal with honesty. If it's a question of fair dealing, again, English law has lots of mechanisms to ensure that unfair dealing is dealt with properly. So, for example, in the Unfair Contracts Terms Act, and in other respects as well. That's how English law has always developed. So, Vasanti, the question I would like to ask you is that given all those mechanisms that are available in English law, does it matter if English law is perhaps out of step?
Well, can I deal firstly with your point about there not being a clear meaning of the concept of good faith? And this was a point that Simon also made. I think the point has been made in the case law in this country that good faith is very susceptible to its context. And where one has got an express term in a contract providing for parties to act with, for example, the utmost good faith towards each other, judges have been able to construe that and give it content. A recent example is Berkeley Community Village and Pullen, which was a case decided in the Chancery Division. It concerned the obligations of a property developer, and the clause in question required parties to act with the utmost faith towards each other in promoting the land in question. Now, Mr. Justice Morgan was able to give content to that express term, and he said it imposed on the defendants a contractual obligation to observe reasonable commercial standards of fair dealing in accordance with their actions which related to the underlying agreement, and faithfulness to the agreed common purpose and consistency with the justified expectations of the other party. Now, good faith in that context was capable of being interpreted in a manner which enabled the court to give effect to it. Likewise, Emirates Trading Agency and PMEPL, which was a good faith discussions clause, which obligated parties to engage in good faith discussions before they commenced arbitration against each other. The judge, Mr. Justice Tier, in that case, was able to give content to the meaning of that express term. He found on the facts it hadn't been broken, but he was persuaded by various Commonwealth authorities, including Australian authority, that the difficulty of proving breach of that term doesn't mean the term isn't certain or can't be given content. So I think it depends on the context, and if parties have gone to the trouble of actually spelling out an express term in their contract, which requires obligations of good faith to be observed, then it would defeat the expectations of reasonable men, to coin the phrase of Lord Steyn, writing in 1997, actually, if one were not to give effect to it. Yes, the meaning is not set in stone, but it's something that we all recognise when it's before us. And my view is that there is a certain basic level of conduct which is necessary to the proper functioning of commerce. That's been recognised in Canadian cases, ostensibly and most recently in their Supreme Court decision in Basin and Rhine. And it seems to me that we shouldn't be shy of giving content to that obligation, especially when it is in the form of an express term. So I'm now going to turn to the main question, which is, does it matter if English law is out of step with other jurisdictions? And my answer to that is, it could matter. If English law is to continue to serve the international marketplace, it cannot remain impervious to ideas of good faith, which have gained wide acceptance internationally. If there develops a perception amongst international clients that English law fails to strike the right balance between certainty and predictability on the one hand, and giving effect to the reasonable expectations of honest men on the other, then other systems of law may start to feature in choice of law clauses. I think there's much to be said for proceeding in an incremental way, as has been done recently in connection with implied terms of good faith in relational contracts, the Bates and Post Office type analysis. But I think English law should be willing to gain assistance and inspiration from the laws of other countries, in which apparently satisfactory solutions to similar problems have been found. And in my view, that will enhance the reputation of English law. And as I say, I think there's much to commend the Canadian law approach in the Supreme Court decision in Basin and Pryneu. There are 2 pending Supreme Court decisions in Canada which will look further at the doctrine in the context of contractual discretions and termination clauses. And it will be interesting to see whether they go along the UK road of carving out exceptions for those and not subjecting them to good faith qualifications or not. But what Canada has done, and I think has done in a very open and transparent way, is to recognise that there is an organising principle of good faith. It reflects the expectations of businessmen, and that there should be some broad principle which ties together all of the piecemeal attempts that we make to achieve justice under our system of law. So that's my contribution on that point.
Well, I'm going to press you, if I may, just a little, Vasanti. Everyone talks about the reasonable expectation of parties. In a commercial contract, the reasonable expectation of the parties will be defined by the words that they have used. It may be giving one party an option of some kind, whether to exercise certain rights or to terminate a contract, or to extend a contract. It varies. But why should good faith, and I completely agree, where the parties have expressly agreed that some right or obligation is circumscribed by an obligation of good faith, I quite understand that. But we're here talking about whether or not English law should adopt a general doctrine of good faith. So we're assuming nothing in the contract. Now, in those circumstances, why should English law put a gloss over an express right of a party to do what the contract says that party is entitled to do?
I think if there is an express right in a contract entitling a party to act in an unfettered manner, then it doesn't form any part of the law's obligation to cut that down unless we're falling within a statutory framework of unfair contract terms or consumer legislation. But where the parties have not expressly legislated for a standard of conduct in relation to particular matters, and you have a contract which is intended to be long-term, is intended to really only survive if the parties properly cooperate together, then I think there is scope for giving content to what the parties must have necessarily understood would be part of their contractual set of obligations, and do it as an implied term of good faith in contractual performance, much as as Mr. Justice Fraser did when he fashioned his implied terms in the Bates and the Post Office case. But I'm not suggesting that it should do away with certainty or that it should do away with freedom of contract. Parties are free to make whatever bargain they like. And given developments in English law on the highway of good faith, it may be that they will wish expressly to contract out of any implied terms and simply stipulate that insofar as it's not been provided for expressly, there are to be no further terms to be implied as a matter of law or fact.
Right. Well, I'm not sure any of my other panelists want to chip in.
Well, I wouldn't mind chipping in, Bernard, if I may. I mean, I do have some difficulty, I have to say, with this idea of categorizing a contract as a relational contract and using from that a set of obligations which arise as a result. It's not the way in which the law normally operates. Relational contract, not relational contract, due to good faith, not due to good faith. My preferred approach actually is to look at the particular issue which arises and work out whether, having regard to the context of the contract, including the length of the contract and the circumstances in which it arises and the purpose for which the parties are contracting, what the parties have or should be taken to have agreed, rather than saying it's a relational contract and therefore that gives rise to a whole sort of list of obligations or a particular set of obligations. And so if we take, for example, the concept of a termination right, let's take that as an example in the context of what Vasanti would call a relational contract. Vasanti accepts that if the parties have expressly said that termination right is a right which should be capable of being exercised in the interest of one of the parties, the court should give effect to that. I entirely agree with that. I don't think that can be doubted. But very often the parties don't say that expressly. They simply say that there is a termination right in the contract. And the question that arises is, should that termination right be subject to a duty of good faith or not? Surely that's a question of construction. Surely that is a question of deducing whether the parties have agreed that it should be subject to good faith or a right which is exercisable purely in the interest of the parties based on normal principles. I don't see where the duty of good faith comes in.
For myself, I am very concerned about this pussyfooting around of having incremental developments in the law of contract. I obviously respect Vasanti's views, and indeed Lady Arden in her speech to Singapore a few years ago echoed the same sentiments. Let's go for incremental development, she said. But I would suggest that actually is a recipe for litigation. There's uncertainty, people will try it on. Apparently this year already, 4 people have tried to argue in the High Court that they had a relational contract, and on each occasion the judge concerned pushed it back. I personally would like to suggest that we go for something simpler. Why don't we do a cut and paste job, as a transactional lawyer like myself often used to do? And the law I would go for is the newly introduced Chinese commercial code, comes into force 1st of January next year, which has some very simple, straightforward principles about good faith, which I think are quite sufficient. So I personally would like to see a statute dealing with the matter. I would not like to see the continued development by the judges, but I would also like to see if there is a statute that is properly examined by the Law Commission and also by the Financial Markets Law Committee.
If one looks, taking up Vasanti's point about incremental changes, if one thinks back over the last, 30, 40 years, what is one of the biggest incremental changes in contract law? And I would suggest that one of the biggest changes is the suggestion that an innocent party, when faced with a wrongful repudiation of a contract, may not have an unfettered right to either decide to bring the contract to an end or continue it. And the way I think continental lawyers might well deal with that under a good faith banner. And we eschew that generally, but in England, there has been introduced the idea that an innocent party may not have, and these are the words, a legitimate interest in continuing the contract and keeping it alive, and may be, I'm going to use the word, obliged to bring the contract to an end, or the law will treat him as that. Now, that I regard as a major incremental change in contract law, because it dramatically affects the rights of an innocent party, and the introduction of a concept of legitimate interest or no legitimate interest is really a different name to good faith. What you're really saying is that the innocent party acting in good faith does not have a right to continue to claim under the contract. Now, do my panelists agree that that's kind of incremental change is right? Do you think that really is an aspect of good faith or not?
I think that's a really interesting observation, and I do think that it can represent an incremental development of the good faith notion in the way that you've suggested. And I think that the times in which we're living, COVID-19, and what the government came out with in May, they issued guidance, quote, strongly encouraging contractual parties to act responsibly and fairly in the national interest in performing and enforcing their contracts, I think will encourage people to analyse more critically whether there is scope for further incremental development in how one treats termination rights, exercise of option rights. The fact that it may be that one can entertain these arguments is no bad thing. I mean, it's for the arbitrators, for the judges, to create the right balance between certainty, justice, predictability. And I think the fact that the advocates now have a lot more tools in their armoury to develop these arguments is a great thing.
Let me move on to another question I'd like to pose to Richard. From the point of view of in-house counsel and their employing institutions, would they, is your view that they would welcome the availability of a general doctrine of good faith?
Thank you, Sir Bernard. I think it's very appropriate that you should ask someone with in-house experience that question. Because although for those who have yet to smell the coffee, it is in-house counsel who in practice determine many issues. They're involved with the negotiation and settlement of contracts, and that includes choice of law, to follow up on Philip Wood's point. It will include whether or not to include an express good faith clause. But secondly, in-house counsel also have responsibility, universally I would say, for the settling of disputes. It is they who will have oversight of the settlement process. And almost certainly the board will be heavily influenced by their views. Some people mistakenly think that in-house counsel are a new invention. They talk about our appearance on the scene as if we've not been there before. How very wrong that view is. In-house counsel were at their most active, at least as active as now, in the mid-19th century. And I'm glad to say there were hundreds of in-house counsel employed in the railway companies. At that time, there had to be extensive use of parliamentary legislation, and the story is told of one in-house counsel who wanted to divorce his wife, so he just slipped a clause into that effect, very comfortable that no one would read it. But I would like to turn for a second to what are called the FIC markets. That's FX markets, interest rate markets, commodities and credit. They're part of the wholesale financial markets. Now in those markets, uncertainty would be highly desirable, highly undesirable. Certainty is everything. And there's perhaps good reasons why it's also undesirable. I think the first is that there's a level playing field. Both sides have access to leading counsel. Both sides, generally speaking, have access to the same information. Secondly, I think that in those markets, anyway, people expect the other to be opportunistic. That is the nature of them. What worries me and continues to worry me about the question about a general introduction of good faith is what, in Lord Neuberger's words, is the concept of unexpected consequences, the law of unexpected consequences. And it's for that reason that I feel this issue needs to be referred to the Financial Markets Law Committee. The Financial Markets Law Committee is a group of 12 very experienced lawyers. Simon is one, Brad Gans from Citibank is another, Sir Robin Knowles is another from the judiciary, and there were senior barristers as well. It's a unique body under the chairmanship actually of Lord Thomas, who's our president, but he's also chair of that body. And the secretariat is headed up by Joanne Perkins, who I think we'd all agree is one of the sharpest intellectual knives in the drawer. So I am concerned about unintended consequences, and I would suggest that it be referred to that body.
Right. Thank you for that. Olga, I have kindly been monitoring questions coming in. Do you have questions from the audience?
Sure. There are several questions from the audience, and if I may, I've sort of grouped them into 4 composite questions. The first is really a combination of 2 very opposed questions, one of which goes as follows. Is it not the case that if parties do not behave in a way that exhibits good faith towards one another, the contract that they're entering into is fundamentally flawed for a lack of meeting of the minds? That's one sort of somewhat extreme question. Another question looking at the same sort of fundamental topic is to say that under English law as it currently stands, the principle of not lying to one another in terms of the parties' expectations when entering into the contract is something that's reasonably well established. That principle can be extended potentially towards not lying to one another during the course of the contract, but that it is quite a different thing to actually be suggesting that parties must use their rights under the contract for the purpose that they were intended, or perhaps to use the term that Vasanti mentioned a minute ago, that they must meet the justified expectations of the other party. So I would start with those somewhat opposite questions, if I may, to whomever would care to.
Let's start with Vasanti, who's taking on the role of the champion of good faith. I can see this here. What do you say to that, Vasanti?
Well, I think on the meeting of minds point, it's quite difficult to try and unstitch a contract based upon the private intentions of parties at the time they sign on the dotted line. I think one has to judge whether the contract in its terms is a complete contract, and if it is and satisfies all the other conditions, then it will be enforceable. And if one party in the course of it, in bad faith, breaches one of the terms, then the breach itself will entitle the other party to a remedy. So I think private intentions probably isn't going to get us very far in advancing the development of the concept. But perhaps at this point, I might just mention something which struck me as Olga was reading out the question. And that's something which was, I think, a comment of Mr. Justice Leggatt all those years ago, and he was delivering lectures to Combar. And he was talking about the tendency of English commercial lawyers to view commerce as if it was a kind of Darwinian struggle in which everyone is trying to gain at the expense of everyone else. And he said that that view may have been encouraged by our experience as lawyers dealing with litigation. But his view was that it didn't correspond to the commercial reality of what goes on at the time of contracting. And he said he believes it's a mistake to see contracting as an essentially adversarial activity. The essence of trade and commerce, he believed, was reciprocity, which benefits both sides and makes each party better off. And that to achieve that mutual gain, parties cooperate with each other in various ways, and contract law should facilitate that by giving it legal backing. And I think it flows from that, that if contract law is to perform its function effectively, it has to recognise that not all the shared understandings and expectations which the parties have and which are necessary to realise their joint aims are ever expressly spelt out in the contractual document. And you have very few, if any, contracts which have a clause by which the parties promise not to lie to one another, because that's just something which is naturally taken for granted. So I think that when one is looking at the role of good faith, it certainly at its core does amount to honesty, and there must be a basic expectation on both sides, if they don't expressly contract out of it, that each will perform in a manner which will not result in the other being deceived, which will not result in one lying to the other, to use the phrase I used before. So I think that background perhaps explains why one has a certain disparity of approach as to the role of good faith and whether it is already implicit in what parties have agreed to do in coming together to contract.
Right.
For myself, I agree with Vasanti that you're not going to find an implied term that I can lie to you during the performance of the contract, or for that matter, an implied term that I can be fraudulent. But it seems to me that the difficult question is regards to termination clauses. I have a right to terminate. It actually suits me to terminate, and so therefore, to that extent, I'm in good faith. But nevertheless, I have the right to do so, and then go ahead and exercise it, as in the Charter Party case mentioned by Philip in his book.
Well, good faith is an altruism. And if you've contracted for a right to terminate, then you're entitled to exercise it.
Yeah, but I mean, that's the point. Thank you for mentioning that case, Richard. That was the famous Monday, Friday case, which I always used to ask students about. There was these international students. I say, now, English, there's a lot of difference on contract law. And in this particular Charter Party case, the charter hire fell due on the Sunday. So the charterer paid it on the Monday, thinking it must be the next business day. But no, it's had to be paid in advance. So it should have been paid on the Friday. By that time, the ship owner had cancelled the contract and took back the ship, and the House of Lords said, that's fine. It was clearly a commercial abuse. I mean, it really was, because charter rates were going up. But if the ship owner wasn't allowed to do that, then they would have been liable for extreme damages. So the House of Lords said, what are we supposed to do? This is business to business, no disparity of bargaining power. Is it 3 hours, 3 days, 3 weeks, 3 months, 5 months? What is it? If you want a grace period, you put it in. Now, that was a really, I thought, commercially abusive case. But I think the result was right, because that's what they had agreed. It was misused, but then you have to say, is there such an enormous abuse that we have to stop that? And frankly, certainly in my experience, which I don't speak very narrow maybe, but in financial markets, I don't think it has been much abuse. I used to do practicing law for about 40 years, and I only accelerated one loan in my whole life, actually a whole lot of them. And that was at the time of the Iranian Revolution, which was rather different. So, and actually the students said that the students in their jurisdictions always came back and said, we wouldn't do that.
Most arguments, in my experience, that raise the question of good faith, raise it in that context, where there is either a right to terminate, or there is a right to extend, or there is some other kind of contractual option, or there is a claim for what would otherwise be a continuing debt of some kind, or when I use the word option in the wider sense, where an innocent party, as I've said before, is theoretically entitled to bring the contract to an end. It's in those areas, I think, that questions of good faith really come into play. Where one's dealing with broader questions was, well, should someone be entitled or not entitled to lie during the course of the contract? English law has very good mechanisms for dealing with that already, without reference to good faith. So in a way, I regard the debate as being somewhat either clear on one side or clear on the other. And going back to the question that I keep on asking is, do we need a general doctrine of good faith? And I think this is what Lord Justice Morbick said in Cottonex, basically, and Lord Justice Bingham 30 years ago, that English law proceeds on a piecemeal basis, so looks at questions of misrepresentation to deal with that. It looks questions of legitimate interest to deal with questions of perceived unfairness. So that is what how I see English law. Simon, did you want to chip in on this?
Well, my view is that we probably don't need a doctrine of good faith in that sense. And Vasanti has correctly said entered contracts in which it's possible to imply obligations into contracts, and obviously there's no problem with that. But the way in which the law tends to work is you don't imply an obligation of good faith into a contract per se. You imply an obligation not to do certain things or to do certain things in particular contexts. And I think the difficulty I have really is moving away from that traditional approach based on the implication of terms to using it to imply this rather general nebulous doctrine with very little certainty as to how it's going to be applied in particular contracts, in particular contexts. So I'm not sure that we do need to have that concept, and the law can deal with it by using one of the other mechanisms that Bernard has mentioned.
I think myself, in relation to swap contracts, one needs to be able to act to one's own advantage. So if I'm in the money and there's a chance to close out, then I think I should be able to do so.
There's another question. I want to come with more questions from the audience, but I'd like to throw in one thought at this stage, that if we did have a general doctrine of good faith, how would that affect the duty of disclosure in the course of a proceeding, either litigation or arbitration? If questions of good faith do come into it, will one party or the other party be entitled to get disclosure of documents which might show the real reason for a particular course of action? Don't answer it now. Let's go to another. Olga, let's have another group of questions, if you can.
Sure. Well, actually, what was just discussed a moment ago neatly segues into my next group of questions, which is perhaps to ask whether the doctrine of good faith has a place in some areas of law and of dealings, but not in others. So I think Richard mentioned earlier consumer law as potentially one area where there is an imbalance between the parties' bargaining strength that might merit the introduction of a doctrine of good faith. One of the questions from someone who was pleased to hear that Vasanti mentioned the Braganza principles and was involved in the case, noted that in their opinion, this basically implies an obligation of good faith in employer-employee relationships. So perhaps if it's not generally applicable, are there specific areas where it's applicable? And then perhaps translating it, since this is for the LSLC, after all, into a shipping context, I'm sure I'm not the only maritime lawyer on this call that has had to look at doctrines like good faith and frustration of contract more often since the onset of COVID than in the rest of our careers. And so situations like MOAs where, the contracts for the sale of a ship affected COVID, where there is a debate about whether you have done everything you need to do to send divers to inspect or you haven't, because it neatly suits you to try and terminate the contract because the market has moved. The few questions that were around that area were around the concept of efficient breach of contract in commercial dealings, and also terminating a contract for convenience. I think termination of contract was already addressed, but the behavior of parties to meet conditions of a contract is, it seems to me, an area where, at least in shipping, you can have quite a big gray area in terms of how good faith might actually apply in practice. Sorry, it was a long composite question.
Well, any of my co-panelists, my co-gladiators,
Well, I mean, perhaps I can address that. There are definitely areas of contract law where duty of good faith actually is implied into contracts and is implied sort of very successfully. And one of those areas is the Leggatt type situation, where one party has a discretion to do something under the contract, and as a matter of the construction of the contract, that discretion is not intended to be exercised purely in the interest of the person with the discretion, but is a quasi-expert role, or it's something which is implicitly to be done to take into account the interests of the parties. And I have no difficulty with that. The reason I have no difficulty with it is that is what the parties have agreed. They've either agreed it expressly by putting in an express duty of good faith, or if they haven't done so, then that is implied as a matter of fact by virtue of the context in which the discretion arises. It's quite different from saying that the duty of good faith is imposed even if it can't be justified on the basis of an express and implied term.
The problem with that, Simon, if I might be difficult just for a moment, is that let it be assumed you have a commercial contract. And let us assume that there is a clause in the contract. I've never seen this, I should tell you. But why don't we have a clause that says all rights and obligations under this contract must be exercised in accordance with good faith? It's not very dissimilar to the Order 1, I think it is, of the Rules of Court in England. Somehow or other, there is an overriding obligation, an overarching obligation that affects all the obligations, rights and obligations in the contract. So let's assume you have that. I think one of the problems with that, I think, is that it might be said that English law, and by that I mean English judges, would take the view that that clause is unenforceable. Now, my question to you would be, let it be assumed you have that clause in its widest possible, formulated in its widest possible way. Would you enforce that or not?
Well, I would enforce it. I mean, I think the job of the courts is to enforce contracts. The job of the court is not to try and find contracts unenforceable for want of certainty. Right. So I just think the courts have to do their best.
Right.
And maybe the answer is that in certain sort of aspects of the contract, the duty of good faith has a very limited scope. There's a very wide margin of discretion. But I do think that if you put in a provision into a contract, it should be enforceable.
Right.
I've got 5 cases here.
I'm not going to ask Vasanti, because Vasanti will say, of course. But I am going to ask both Philip and Richard, if I may.
Well, I think the answer to that, I mean, I haven't read all these cases, but I've got a note here at least. I've done due diligence on this thing. I've got 5 cases in which the court did apply a good faith term. I don't know what they said, in particular cases, but I thought the position in English law was that you have the choice, and it's frequently put. I mean, you've got it. I don't know how many times in the derivative in the master agreement, but at least 2. Where it talks about, good faith. I can't remember what there do appear to be these cases where you do have that option. So what English law is basically saying, either you can have what is, quite a predictable system, but you can opt and say, I want palm tree justice on the day. I'm very happy for the court to decide what's fair. And there you're opting for something which is unpredictable, but you're leaving it to the court to decide what's fair rather than the parties. And right. I thought we could do that, but maybe not.
And Richard, would you enforce that clause or not?
Well, I'm a palm tree justice person myself, so I go with Philip. A question I'd like to put to Simon is, particularly in the consumer context or the small and medium enterprise context, I think we'd all agree that there can be an inequality of bargaining power and information. One solution advocated in a recent publication by Queen Mary is that, for example, banks should owe fiduciary duties to customers, so go beyond good faith and put it as a fiduciary duty. Do you think that's a good idea?
I'm not sure about fiduciary duty. Really involves subordinating your own interests to the interests of the counterparty, which is sort of a bit antithetical to a trading relationship. It's not necessarily antithetical to a customer banking relationship. But
I was thinking in terms of assignment customer banking, and I take your point that, you know, banks are in the business of banking and making money from it. But I'd be interested in your reaction to it in principle.
I'm sceptical about a fiduciary duty. I can see an argument for saying that there should be more protection to customers or certain categories of customer. I think that is quite different from imposing a duty of good faith. You can have something like
fiduciary duty,
or indeed a fiduciary duty.
Thank you for that. And Olga, I think we have time for one more question or group of questions if you have.
Yes, so this one will be short. If you do find that the good doctrine of good faith to a contract, whether it because it was written in or because it fell into a specific area to which it applies, what then would be the remedy for its breach? Absent obviously a breach of a specific other contractual term.
Right. Vasanti.
Well, if you have a good faith obligation requiring you to negotiate and attempt to settle your disputes for a period of, say, 3 months before you can arbitrate, and you refuse point blank to enter into any good faith negotiations at all, the consequence would be that you can't commence arbitration. So it would be a conditioned precedent to the right to commence arbitration, assuming you've drafted your clause or the effect of the breach was held to be equivalent to non-compliance with a conditioned precedent. If you've got good faith impairing the exercise of a discretion, then it would be an invalid exercise of discretion. And if you had terminated on account of your invalid exercise of discretion, then the contract would be invalidly terminated and you'd in turn be liable for damages. So I think it depends in what respect your good faith obligation is breached. But it certainly gives rise to real remedies and is not just something which is of a declaratory nature without any real impact.
But the way you phrase it, Vasanti, and I'm not disagreeing with you, that failure to comply with, let us say, a general obligation of good faith would in effect operate negatively. That is, it would operate to stop you exercising what would otherwise might be your contractual rights for some reason or another. But do you think it could go further, that there might be a positive claim for damages for breach of a duty of good faith? Why you're thinking of that?
Yes, I mean, I think it could in certain circumstances. I mean, on the facts of that Canadian case in the Supreme Court, it basically led to one party's continuation of the contractual relationship being brought to a premature end, and the damages that were consequent upon that would have been the damages for breach of the good faith terms. So I think in an appropriate case, yes, it could give rise to a damages claim.
Right. Simon, you can't possibly agree with that, can you?
I think that I can't see why, in principle, it shouldn't be capable of giving rise to a damages claim if you've suffered loss as a result of a breach of an obligation that you've undertaken in the contract.
Well, it depends. I mean, for example, traditionally, everyone has always said that equitable estoppel can only be used as a defense. It can't be used to found a positive claim of some kind. So one possibility might be that even if we were to have some kind of general doctrine of good faith, it can only operate negatively, not positively. What do you say to that?
Well, I think this would be characteristic of English law proceeding incrementally, preventing floodgates, and I think assuring those of us who are worried about the lack of certainty and the overriding of our freedom of contract. So I think it would appeal to English lawyers to have that differentiation.
Right. Philip, a differentiation that is attractive to you or not?
Well, I don't know. That's too big a question, I think. I mean, I would only just say that the things we're discussing, English law is a million miles away from the other legal systems I mentioned. You know, they're all within the legitimate areas, but we are a million miles away from them. They override contracts, you know, what they expressly say. And that's, you know, you can have a debate about that. That's about reasonable. I think all of the solutions which we presented around the world and all the other legal systems I mentioned have been incredibly successful. So they're all very good. So, but this is a point on ideology, which I think we differ. And, you know, at least people have the choice. I think choice is really important in the world at the moment.
Richard, a final word on that. Would you be see a possibility of that or not?
I agree with Philip.
Well, yes, I'm not going to express a view. Right. Well, we're coming to the very end of this webinar. There are still a large number of people attending, but I hope that looking at the attendance list, it is involved, or a number of people from all around the world have participated. And I think I was cut off at the beginning, but I did want to say that I do regard this as a hot topic. And given that Lord Leggatt, the young Mr. Justice Leggatt, has been catapulted up to the Supreme Court, and that he is the champion of good faith, that I think the next few years, unless he can be reined in, we'll see potential developments in this area. So I would like to thank all my panelists. For those attending, a lot of work goes into these actually, and I've enjoyed our preliminary discussions and how we should format this webinar. So my thanks go to everyone involved, to Vasanti, to Simon, to Richard, to Philip, and to Olga, all of you for your help in putting this all together. There are a number of people behind the scene I should thank. There's James Holliday, I think, at Linklaters. There's Josh at Linklaters. I forget his surname, but Josh has been magnificent. There is Paul Martinson, the director of clerking at 36 Stone, who has also done a huge amount of work and who I'd like to thank. And also, last but certainly not least, is Gerard Matthews and Aleka Shepherd at the London Shipping Law Centre. Particularly Gerard at the sharp end, he's been helping put this together over a number of weeks. So to all those people, I would like to express, I think on behalf of all my co-panelists, a huge thank you. A huge thank you to everyone who has participated around the world. I hope you, I said at the beginning, I think there were over 900 people registered. I'm not sure whether this was, if you had heard me before, I'm not sure whether this is a world record for a webinar or not, at least of this kind. But it does show the real interest. And I hope that the discussion that we've all had has been of interest to everyone around. I think one can only end this by saying, watch this space. Anyway, thank you, and goodbye to everyone. Thank you very much indeed.
Our great thanks to you as well, Bernard. Thank you very much indeed, everyone.
Thank you.